Good morning, everybody. How are we? Welcome, welcome, welcome. So glad to have all you guys here this morning. Hi, Fly Girl. How are we? Bama Green Eyes. What's going on? Miss Lori, glad to have you back, honey. I hope you're feeling better. Lynn, Miss Charlotte, Steve, Melanator. Good morning, Mel. Hi, Dee Dee. I don't know why the top of my screen is like, oh, there it is. Okay, I fixed it. Debbie Hubbard. Good morning. Is it still on schedule? As far as I can tell, Debbie, this trial is still on schedule. Unlike the last time we tried to do this, there was a thing last time on that last court case that there was a notice that they had, what is it? Not withdrawal. They basically said they didn't need to meet in in modern day terms. There's nothing going on here on this one. They're still scheduled to be here this morning at 9 a.m. So it's about another 15, a little bit more than 15 minutes, and they usually do not start on time. Now, just to remind everybody, this is the male judge who is that we're seeing today. This is not the female judge. So, what is this court case all about? Well, let me tell you. This is the one that was filed in July of 2020, and it's 2 charges for second degree recklessly endangering safety, use of a dangerous weapon against his mother and his nephew, and also for possessing firearms as a convicted felon. And just so you guys know, I made a special point because everybody was like, oh, he's going to try to defend himself. He's going to withdraw counsel. Nope, they pulled that out. They pulled that out in March. And it was kind of weird too because in, let's see, on what day was it? February the 2nd, they said they were going to do that defense. They motioned to withdraw the defense attorneys. And so we were all like, "Oh my gosh, he's gonna represent himself." And then they came back on March 23rd, not even 30 days later, and said, "No, we're gonna pull that withdrawal or pull that, and we will be having counsel." Now, whether or not they're gonna show this again, so I'm gonna give you guys kind of a warning. Last time we got on here, we were all excited because we hadn't seen our old buddy Joel in a while, and we waited, and nothing happened. So I want to show you guys what the court looks like. I guess I could pull this up. Oh, it's up. Okay, I'm feeling really good about it then. Let me go ahead and live stream this so that you guys can at least see what's happening. Because last time we didn't even have a stream of anything going on. There was like the court system. I think they were having problems with their live stream that day because I went through every single thing on there. I went through all the different branches to see who was live streaming. None of the live streams were working. Hang on. I'm getting there. I'm getting there. It just takes me a little bit longer than some people's, because it's Monday morning. I sat by the pool this weekend, you guys. I did a lot of drinking. We drank a lot this weekend. It's college baseball season. I don't want to do that. I don't want to do that. Hang on. Help the blonde. There he is. I found it. I found it. All right. So what'd y'all do this weekend? I know I gotta take this off the screen. Hang on. And I gotta fix this. There we go. Now see, y'all see what I see now. Does that make everybody happier? Happier? All right. Motion to adjourn was at the last hearing. Yes, thank you, Steve. That was the word I was looking for. Adjourn until July 21st pretrial and August 40. Yeah, they ended up that was Erica's case and they ended up pushing it back. And honestly, everybody was going, "Oh my gosh, what's going on?" I think it was a scheduling thing for one of the attorneys because when they tried to set this date, I want to say it was Darrell's attorney said he might have a conflict. And they said, "Well, we're going to go ahead and schedule it and we'll kind of deal with it if that happens." And I think that's what happened. And I guess they do that because, things happen. They changed court dates constantly. Look at Suitcase Sarah. How many times have they changed hers? Hi, Lance. How are you? Brooks said the show must go on. As long as I don't. No, I did not do any driving this weekend. The pool is right here in where we live, so I was good. Yeah, that's why I like doing that. And if we have friends over, we just throw them in the guest bedroom. We're like, you're not drinking and driving. You stay here for the night. Sick of Mr. Grounds. German festival. Hi, Steven. German festival in Chicago. Oh, y'all had Mother's Day this weekend? Oh, you have it, Charlotte. You're in France. Y'all have it at a different time than we do. That's interesting. Lori made homemade spring rolls. I've never tried to do that. I have never tried to make any kind of Chinese food at home. It's just too good at the restaurants. I don't even bother. We did a lot of barbecuing this weekend. We did chicken wings one night on the grill. We barbecued them. And then we did ribs last night. My brother-in-law is like a kick butt griller. He's like the man on a grill. So we really enjoyed that. That was good this weekend. My sister has an air fryer and I've never used it. So I wonder. I've never tried it. I need to do it though. Well, I want to welcome everybody that's here today, even the ones that aren't chatting. I know I tend to kind of chat with everybody a little bit, but right now we're just waiting for them to start his session. And when they do, I'll pull up the sound on it. Let me see.
We are on the calendar today for scheduling. I think we were last in court on May 1st.
Yeah,
when
we're
we set
good.
the matter.
We're good. So I'll just turn that volume back on when we need to. Hi, Lady Bumpus. I said Bumpus. Is it bump ass or bumpus? Joe Love. Did I miss anybody? Linda's coming in from Ontario. Awesome. Ames. Yeah, the court usually goes live. They start streaming it, and then we'll just have to sit here and wait. And when these people move, our old buddy will come on in with his attorneys. And just to be on the safe side, I've got a couple of backups channels in case we have issues. I don't know. It's kind of weird. The media's kind of lost interest in this. I think they don't realize how into it we all are because they didn't even law and crime. No, they didn't put anything up on his last appearance. But again, I think that might have been something going on with the court's live stream. I really do. So yeah, I've got a couple of lives going on the back in the background to see if anything happens. So who's gonna watch this OnlyFans model trial? Because I don't want to watch her. I think she's an abuser. That elevator video of them, I was like, oh my goodness, she's the abuser in the relationship, and he was taking it. Terrell is only entertaining when he's representing himself. Yes, this is so true because you know what? He doesn't. He just sits there in his little wheelchair. And the last time he was on, oh, I had to do a double take. I thought, ooh, prison is not doing him good, honey. Oh no. Not Mel's not interested. I'm not either. I just don't this OnlyFans model case, I don't know. I think it's been overly done. And it's funny how the media will put a take on something. It's like, okay, for instance, if like let's say something were to happen to me and they were to do something and they were to run a story on me, they'd be like, "Oh, um, YouTuber Carrie blah blah blah." I mean, they'd make it out like I'm this big YouTuber. Just like they do with the big TikTokers. It's like these social influencers. And really they might not be that big. Oh, Abby, you're into it. Yeah, I don't know. I'm holding out for Sarah. I get I'm sticking with Darrell and Sarah, Suitcase Sarah. I do want to live stream those. So for anybody that did try to click on my video that I was trying to upload this past weekend, it was a documentary. I had to pull it back down. I'm having problems with YouTube as far as doing uploads and trying to get. They keep every frickin' thing I upload. They're demonetizing it, saying that it's not ad friendly. And I go back in and I tweak it and I try to do what I can to it. And then there, it used to be that you could just do that. And within like a couple of hours, they'd review it if you needed them to review it like a human review. Now it's taken like up to 7 days. So for the last 4 days, my video has been sitting there waiting for human review. And I'm just like, really? But as soon as they approve it or whatever they end up doing to it, then it'll be up. If they don't give me that monetization on that thing, I don't know what I'm gonna do. I I'm floored by that. I'm floored by spending so much time on something and trying to follow the guidelines and then them just and they won't even tell you what it is. Okay, so Steve says the judge for Erica's case can deny his request to self-represent and let him appeal it after the trial. He will still be behind bars for 6 lifetimes and 760. I know. And a lot of people are really upset that they're having to redo these trials with him or do these extra trials with him because they're saying, well, they're wasting taxpayers' dollars. But the thing about it is that I guess when he was on the appeal that he had out there for the big case, they're saying if anything ever falls through with that, we need to make sure this animal stays in jail forever. So we got to have these ready to rock and roll. And to the victims need their day in court too. You can't discount that. Oh, thank you, Mel, for watching my video. Did you like it? What did you think about it? I really love doing those documentaries, you guys. They're fun. It takes me a lot longer to get them done, but I really enjoy them. Let's see, Mandy. Hey, Mandy, how are you doing? All right. I'm going to let me go onto Twitter real quick and post the reminder on this video. Y'all can chat amongst yourselves. So Steve's talking about Sarah's trial getting pushed back. He thinks it's not going to be till September. I don't know, Steve, because I mean, well, right now we've got it scheduled for July. Let me pull out my little handwritten calendar that I like to keep because I'm old school. So after this for May, or I'm sorry, for June, May's over with, Carrie. Hello. For June, we've got this going on. Then Monday on July the 10th is when Brooks' trial for this trial that we're the pre-trial today. That's when this trial begins. So after today, it will be another month before we even revisit that. Then on the 11th of July, the day after that is when we get to hear what's going on in Sarah's trial because they have that pretrial hearing. So we'll see. Are we still on for July 24th? Because that's when it's supposed to happen. That's a Monday. Gets us that's pretty good because we're past the holiday season or past the July 4th holiday. And then Brooks's pretrial hearing for Erica's case is going to now happen on the 21st of July, which is a Friday. Oh, and even before that, on July 13th, they're doing the sentencing for the Wests. So I want to see that for sure. And I think they were holding out on the sentencing for the West because they were hoping that between them being their verdict being found and them being sentenced, they're really holding out, hoping that they're going to tell us where those babies are. Let's like put them in the proper resting place. So I don't know if that's going to happen. I think if they had spoken up by now, we would know. Um, and then his trial for the case with Erica, for Brooks's trial with Erica, does not start until August the 14th. So it's pretty spread out. Now, it looks like. Wait, when is Sarah's trial supposed to start? On the what I say, the 24th? Well, it just might work out well. It might work out that Brooks's trial with his nephew. I mean, I don't think that's going to be a long trial. What, a couple of days, you guys think? And then Sarah's trial is going to take a lot longer. That'll be a 2-week trial. By the time that one's done, or hopefully it'll be done, the other trial for Erica comes up. Now, there's suspicion that, or talk that Brooks is going to show up via Zoom today. He probably will. We don't, it doesn't matter. He hasn't been saying anything, right? I know. Yeah, you guys like these live feeds. I'm surprised how much people like the live feeds. It's funny. She wrote another letter, Abby. By the way, hey, Abby. Did y'all see that video I did on some of her previous letters? Why is, I mean, she kind of had a point, guys. Shouldn't she be receiving some more correspondence from her lawyer by now? Hello. All right, I'm gonna put the sound on in the background, and I gotta go grab I gotta get a coffee refill. So hang on.
I'll plan on zooming in for Mr. Bowens.
So actually, so that's like when's our trial date? Okay. So yeah, if you're fine with this, we can, and Ms. Bowen's in or out?
I are both in right now.
Should we, he's aware of, all right, so Bones is aware of my request. All right, so yeah, let's just do it by email. I'm on Bowens. We can give them a new final pretrial date by email. All right. So that's going to be, we're set for trial July 10th. I'm down the week of the 3rd. You're unavailable the week of the 26th. And I'm only up Monday, Tuesday, and Wednesday this week. And then next week's a 4-day week. So, our
Thank you.
What'd I miss? I didn't mute myself. I thought I muted myself.
all right, so it looks like we now have Brooks, Rakestraw. Well, he's in, at least there's a booth that's entitled Brooks, so we'll see. He might not be in the booth yet.
Finally, we get to see something.
Yeah, she come in.
I'm gonna mute myself so you guys can hear better.
Good morning.
Well, I don't guess they're talking right now, so I'll just talk to y'all. It's so good to see everybody back in here. It's like the old gang's back together again. The famous quote from the Grease movie. I wonder if he's gonna show up. They said something about him being in the booth. Is that what they're talking about? That lower left-hand corner? No. Are they? Steve, are you speaking with me? The weather where I am, it's been beautiful this weekend. We had a couple of clouds here and there, but for the most part, we got a lot of sun this weekend. We enjoyed the pool both days. Hey, Miss JPC, how are you, honey? Sarah Boone doesn't write letters; she writes dissertations. That's so true. It's like an instructions manual. I think it's going to be quick too, Joe Love. Thank you, Mel. Yeah, you guys, please click the like button for me. I need some YouTube loving. Seriously. Since they made me redo all those Terrell Brooks videos and I had to add commentary, my channel stuff has gone down tremendously. So I kind of had a hiccup in my channel. So I need all the positive feedback I can get at this point. The booth at prison for Zoom. Okay. Yeah. Well, they did have a gentleman on here just a few minutes ago that looks like he was in a booth for the prison, from the prison. So that's good. Then was shackles. There were shock devices on my shackles, Melanator. They were shock devices. Anybody else bothered that he chose to have a fish fillet sandwich during his interrogation? I don't know, Richie. I mean, I have to say I enjoy the McFish fillet. It's pretty damn good. It's one of those sandwiches that it's not real. Like it's probably like fake fish, but there's something about the McDonald's chick fish fillet. I mean, that was his last big meal. I think I would have chosen a Big Mac if that was my last meal though. Or quarter pounder, double quarter pounder with cheese or something. Exactly. Where are his defense attorneys? I'd be pissed if I was the judge and the prosecutor on this.
Come down at 10:30. There's
Oh, hey, show poodles, honey. Okay, listen.
as the presiding judge of felonies, I hear those. So if let's say you were a witness to a case when you're down in Florida,
I want to see what he's here saying.
but you've moved back up here. Florida court has no jurisdiction. So the Florida court has to ask the court in Wisconsin.
I guess they're not talking about anything, but
that you're a necessary witness and that it wouldn't cause undue hardship for you to.
what was I saying? I lost my train of thought. Oh, okay, guys. So when you see a live stream that's scheduled, what you have to do is you have to click on it and click into it and open it up. And then there's a notification button in there that says notify me. So when it's pre-scheduled, like the ones that I have here for Gerald Brooks, I got a lot of them. Plus I got Sarah's already pre-scheduled too on my channel. Go ahead and go in, click each one, click the notification button so that when we do go live, it's going to give you another notification that says we are now live.
I believe they put you on a flight.
Hi, Bobby.
Because frankly, it'd be more expensive to pay you mileage than to drive. Because and then have to pay hotels and stuff. So
Okay, y'all, come on now. What happened? They turned it up. I guess because they're having a discussion in private. It'll come back. Don't worry. Don't freak out on me. It'll be back. I don't go. We know what? When I go to Wendy's, I go for the burgers. I like Wendy's burgers. And Wendy's, for the longest time, they had the best value meal um, available. Because sometimes I'll go to McDonald's and I'll order the Happy Meal for me because that's all I need. All this supersized and everything else they're doing, I don't need all that. Y'all remember when you go to McDonald's and get like a meal for like $4? I do love the Frosties, Debbie. Yeah. Oh, yeah. Oh, Shelly, you know what Dairy Queen used to have in Mobile, where I'm from, Alabama? Dairy Queen had, they would put slaw on their chili dogs, and on the menu, it was called a slaw dog. Oh, my word. That was the best thing at Dairy Queen over here. Y'all are going to make me have to go out and get some fast food today. Oh, was it bad, Richie? I haven't been to a Dairy Queen in so long. Yeah, it's the sweet slaw. You can't just, I mean, for me, it was anyway. That's the way they had it here. It was the sweet coleslaw on the burger. I mean, on the hot dog. Chili. I don't think it had any mustard in it, which, the Checkers has one that you could go get. It's a chili dog, and they put mustard, onion, and chili. It's pretty good. If you have like a hot dog attack, that's a good place to go. Right, Steve? 59 cents. It's unheard of now. And the other thing too was I was just thinking about all these price increases lately. We last week I was on a mission. I wanted to go find a good produce stand around the area where I could go get some homegrown tomatoes. I wanted some squash, I wanted some zucchini. I was really looking for some watermelons. And I had to drive a good ways to go find something. And then the local guy did come around. We have this guy that comes around with a truck every now and then. He stops up at the gas station and we'll go up there and visit him. Well, bless his heart, he's had to up his prices so much because even produce has gone up so high. It's ridiculous. You could used to go to the farmer's market. You could take $5 in cash, go to the farmer's market. You could walk out there with two bags full of stuff. You can't do that anymore. Oh, Debbie, is that what they call a coney dog with the coleslaw? Mm, spicy slaw. Ooh. You know what? That sounds good to make a spicy coleslaw. I usually, if I make it not sweet, I'll make it like with a lot of pepper in it. I'm a big pepper person when I cook. If I do like, I'll steam squash and zucchini with some onion, and I'll put a ton of pepper in it. I know, JPC. I hope you're going to be able to eat when you get back from the dentist. Oh, does anybody have a Mrs. Winters near them? I just had a craving for her yesterday because we were talking about something and it reminded me, oh, somebody over here is going to get some dental work done. And when I lived in Atlanta and I would go get dental work done, there was a Mrs. Winters by our house. So I would go over there and get their mashed potatoes and gravy 'cause it was so good because that was really all you could eat after that. Well, as usual, we're running late on his trial. I wonder if we're waiting. Obviously, we're waiting on him and his attorneys. I'm going to refresh the screen. What are they doing? What are they doing? Oh, I gotta. I wonder what's taking so long. Ames, they will start at 10:30. What are you talking about, Ames? What you talking about, Willis? I'm just looking back on the case files to see if there's any notices on them, and there's not. So nothing's been updated. They probably just put it on pause because they're waiting on his dumb butt. Hey, you guys, I'm hot. I'm gonna turn the fan on. Y'all tell me if y'all can hear it if it's too loud, okay? I'm having a hot flash. Thank you, Mel. Thank you for reminding everybody to hit that like button, please. I appreciate it. It's free. It doesn't cost anything. Okay, Ames says the judge said that they will be in recess until 10:30. Wait, what? All right, 10:30. What time zone? Because it's 9:18 right now where I'm at. Are you telling me it's not going to be back on until 10:30? That's 45 minutes away. He's trying to find his Jeffrey Dahmer glasses. I know, right? Those were awful. Those were so awful. Oh my goodness. All right. Well, while we're waiting, shall we watch a good old Brooks video? Y'all want to do that while we're waiting? I got to pull it up. I don't have any new ones for you guys today. Cuz I went back and looked at my archives. I'm like, I got to put some stuff together. Yeah, I think I'm in the same time zone as they are too, Central. All right, Debbie, go do your walk. But be back by 10:30, honey. So you don't. Oh, come on. Let's live stream some. I'm going to put up something for you guys. Hang on. We ain't going nowhere. We're going to sit right here and wait. Anybody been watching the College World Series or the regionals or the playoffs and stuff? We were so into that this weekend. So all we did was watch baseball and eat and swim and drink on the pool. All right. Hang on. Welcome to 90611 Grounds Prison Radio. Today's sponsor is D. Brooks School of Law. where you can get your faux law license online within hours. Licenses are limited, so please get your tackets now. 90611 Grounds, where subject matter jurisdiction must be proven. We'll resume our program after this quick break and word from our sponsor.
But I would like to advise the courts and the defendant that he's requested a subpoena for a person identified as Sammy. We have learned that Ms. has relocated to the state of Texas. Therefore, we will not be able to secure her appearance here at the trial on behalf of Mr. Brooks. If he wishes to make arrangements for transportation for Ms., he may do so himself.
All right, did you hear the state advise you of that?
Yeah, I wouldn't even begin to try to know how I can do something like that from a jail cell. I'm pretty much broke.
At D. Brooks School of Law, we'll show you how to do all kinds of things, including tell everybody your business.
And you stated that upon seeing the suspect on the porch, that they were gesturing.
Gesturing? Yes, sir.
We'll also teach you all kinds of new words. We even have our own dictionary.
And you made reference to uh, your phone being used, right?
That's correct.
And you also made reference to not being able to hear the person on the other line.
That's correct.
But you also made reference to not person who used your phone not being able or not answering what was being asked to them. That'd be fair to say?
Objection.
There was the Waukesha parade fund that was, I think, an international type of thing. There was, our parish had a fund. There were GoFundMes. There were any number of different things. There were different encounters to allow people to come together and talk about what had happened and seek start healing from the emotional part of it.
And by international, that would be assuming worldwide. That'd be fair to say?
Yes.
Now, don't y'all be afraid to represent yourself, because even when you don't know what to say, you can just say whatever comes to the top of your head.
Your Honor, is that the answer?
Mr. Brooks, I issued a written decision. That's your answer.
And what's that? And what does the written decision entail?
So that was provided to you last week. I'm not gonna
I
go
accept
through it
for
again.
value in return for value the document that I have not seen. What does it entail, Your Honor?
All right, thank you. The record should reflect that the individual known to this court as Daryl Brooks is present in person in custody. He is wearing street clothes, specifically a suit and tie, and he is wearing a mask.
And I do not consent to being called that name for the record.
Noted.
You'll have the prosecution so confused about what to call you that they won't even remember what you're on trial for.
All right, so Mr. Brooks called a witness yesterday. There was an objection. I sustained it, but he also orally moved to dismiss, and I indicated I would take that up outside the presence of the jury. I didn't do that yesterday, so I just want to put on the record that I'm denying the motion without any further consideration or discussion by the parties. He listed two reasons. One was it had to do when he called the state of Wisconsin as a witness for failing to appear.
Calling witnesses is our specialty, and believe me, we've learned the hard way.
So is it fair to say that in your report, you referenced two incident reports?
Objection.
Grounds.
Witness.
I'm going to overrule the objection and let the witness answer it. I think it might just be semantics at this point, but go ahead and ask your
You
question.
mean semantics.
I think you were referring to that he had two.
That's what his report says. He makes reference to two reports, two incidents.
2 incidents,
Yes.
not 2 incident reports. Reports would be separate documents.
You said the individual you spoke with seemed out of place and disoriented, like he didn't know where he was. Would that be fair to say?
That's correct.
And how would you characterize disoriented?
You just seemed very, very nervous and that you didn't know where you were.
Who's you?
You had specifically said, I don't know where I am.
Who's you?
Or where am I specifically?
So disoriented would from your perspective be exactly what? Position that, would it be fair to say that the vehicle passed that position pretty quickly?
Yes.
Would it be fair to say that you can see, I guess it would be some type of lights from the vehicle that passed? Would that be fair to say?
Yes.
And you estimate that where you can see those lights and where you would have positioned that is 10 feet.
Can you repeat the question?
Would you say that where you can see those lights at, that you just said that you can see, and the position that you drew yourself to be positioned in, you would estimate that that's 10 feet?
Yes.
I'll object and move to strike. I think this is a misleading question. We're at the beginning of the video. Those taillights are not the vehicle in question.
Where did the taillights come from then?
A different vehicle.
Don't let this happen to you. We'll teach you how to review all your trial records, all your videos, and how to read witness statements while the witnesses are on the stand.
Anything else stick out to you about that day?
I don't know. Just, I mean, besides seeing the vehicle and the police firing shots and then running into you afterwards, I mean, that was strange enough.
It has to be verified by the prosecution. Or is that a tacit agreement that you don't have to answer that question or verify proof of subject matter
Sir,
jurisdiction?
I have no such agreement with you. Have been advised that all of the jurors are here and ready to go. I presume the state has available its next witness.
We do. We'd also move State's Exhibit 162A into evidence.
As to 162A, Mr. Brooks, any position on that?
Yeah, I object. I haven't even seen it. Would you happen to be on duty today, right now, if you weren't testifying?
Yes.
And so right now, would it be fair to say that you are on the clock?
Yes.
So on the clock, would it be fair to say that you're getting paid right now?
Yes.
Would that be for your testimony or just because you would be on the clock otherwise?
These would be my normal work hours right now.
So you're being paid to testify right now as we speak?
Objection.
Grounds.
Asked and answered.
Grounds.
He may answer.
Yes.
Any idea why you would be getting paid to testify?
Because these are my normal work hours. This is when I'm working and I'm been subpoenaed by the state to be here.
So the state's paying you to testify?
The city of Franklin is paying me.
To testify?
These are my normal work hours.
So testifying in open court is part of your duties as an officer?
Yes.
So you've done this more than just this time then, would that be fair to say?
Yes.
And each time you were paid to do so?
Yes.
At act now because those tacket agreements are limited due to the fact that we have limited internet access. Welcome to 90611 Grounds Prison Radio. Today's sponsor is D. Brooks School of Law, where you can get your faux law license online within hours. Licenses are limited, so please get your tackets now. 90611 Grounds, where subject matter jurisdiction. Welcome to the D. Brooks School of Law Training Manual video. In today's video, we're going to go over a couple of items that help Mr. Brooks. Now, we also have some video footage of Mr. Brooks in his own court case that you are going to find to be critical in your court cases. So we recommend you watch this entire video all the way through to the end. Now, Mr. Brooks does not guarantee that these activities, these items, anything mentioned in the Darrell Brooks School of Law is going to get you off your charges, okay? What he does say is this is going to give you one heck of a chance. But you know what? In life, isn't that how it goes? We kind of all have chances. Before we get started, Mr. Brooks did have a message for all of you.
Ladies and gentlemen, I don't think it's fair to just say guys, but it took a lot of courage and a lot of guts to pause your life for this. I want you guys to know that's not lost on me. I'm sure it's a lot. And you all should be commended because it took courage to do this. I don't know, but I would bet a lot of people wouldn't want to be sitting in your position right now. Hopefully we got a lot of living ahead of us. Lord willing. Don't look back and kick yourself in the behind. Thank you.
Now, yeah, I've got it pulled up. They're back in court, but but I think, but Brooks isn't in there. I mean, I could pull that back up if y'all want to. Hang on.
I want to wait a couple minutes to call Mr. Parker Bell's case because we have Brooks and Hampton and Rakestraw in our breakout room. I think that'll be relatively quick.
Okay, so they got him in there finally.
All right, thank you.
Fly girl left. She's gonna miss it. I can't turn the volume up any louder. I hope you guys are okay to hear it. When he comes in, I'll just mute myself. And I'll try to stay muted as long as I can stand it, but y'all know I gotta say something. Let's see. I know, Linda. Why are we always waiting on him? Always. I actually think they're waiting for the judge to let him in, though, but it seems like they're taking a long time. Didn't he just say we're going to go ahead and take them in right now? They're going to pull them up now? Okay, I'm muting myself while I rant.
Humans.
So here's my thing. What are they prepping to come into court together? They're talking to their client. Okay, I get that, but
Um, Let me see if I can chat in the breakout room.
I mean, common freaking
Well,
courtesy.
I guess what I'm gonna ask is, can I call it and then put them back in a breakout room afterwards? So I'll try this.
Oh, Ames thinks the bailiffs are running behind bringing him in. Girl, Shelly, you know she does. Mama is putting that money in that commissary. And he probably yells at her if she ever does it late. Steve says they have to keep other inmates away from him for his safety so everything goes at a slower pace. Makes complete sense. I get that, but I just think it's rude for the judge. I mean, the judge is like, it's holding up all of court. Yes, Miss JPC, he is king of the world. He thinks he is. Hello, Mr. David. Oh, you guys, while we're waiting, I dropped a video on that Richard Merritt guy that they had on Law and Crime, and I don't think I've been on here and told you guys about it since I started watching it just because I was like killing time, and he was such a douchebag. I had to do a video on it.
I sent a message saying, asking if I could call your case and then put you guys in the breakout room again afterwards. Can you get it done? All right.
Here we go. Maybe. So, um, you guys come here often? How's the weather there? Okay, so you guys think, are you being are you being funny when you say mom's boyfriend, Ames? Mama got a boyfriend? Well, remember we thought it was that one guy that was sitting behind him for a while, and then we saw his video and we were like, no, it couldn't have been him. He's not very bright. Mm, okay. Okay, Miss Melanator. I know, Shelley. It's ridiculous that they do this. Carol's so patient. She's like, "It's normal. Y'all settle down. We're gonna get to it." Jay Prince. Yeah, that's his name, Shelley. He's
Okay, I'm gonna call Parker Bell. And then okay, all right.
Just on the phone. Yes, I'll dismiss the other ones outright and then we'll just do that one.
Okay,
all right. They're gonna call
all
in.
right. Can I talk to the two of you briefly while they're bringing out Parker Bell?
D. Scott, yes, I will be. Anything they're doing on Mr. Brooks, it's gonna be on this channel. If th- so, that I'm gonna ask a dumb question because y'all know I'm not an attorney. Steve. Steve will know the answer to this. This is a trial. This is not a trial hearing. This is a judge hearing, correct? So they're not gonna have like a jury, right? No, not this one, Steve. I'm talking about when they go on July 10th or when they start their trial with him for these charges. They're gonna bring up somebody else while they're waiting on him, guys. So he'll probably be the next one in line. Fireball. Dave.
Yes.
This is pre-trial, Carol.
Okay. All right. Okay, that'd be fine with me.
Okay. Thank you, Steve.
Okay.
Let's hear what this guy did.
Good morning, Mr. Parker Bell.
Good morning, Your Honor. Put your board, what you need.
This is State of Wisconsin versus Darian Parker Bell, case 22 CF 811. Appearances?
Kent Lovern for the state. Your Honor, good morning. This is Mr. Darian Parker Bell. He's in custody. He's present in the courtroom with Nathan Oplendaps.
Good morning. We are on the calendar today for a hearing for the court to make determinations as to the appropriate placement of Mr. Parker Bell and the length of his commitment. I did speak briefly with the lawyers before we went on the record just to confirm that that's the purpose of today's hearing. I do have two individuals from Wisconsin Correction Service who wrote a report for the court, who are present if there was information that was needed or questions. My understanding is the parties are prepared to proceed, and Deputy District Attorney Lovern, my understanding is the state's in compliance with victim notification, and there is a victim who wishes to address the court today. Is that correct?
That is correct.
All right. Anything we need to do before we bring that individual in?
Oh, he could come in now if you'd like to hear from him now.
I guess I'll allow you to make a presentation and do it in the order that you prefer.
Okay, thank you.
Do you want him now?
Okay, well, maybe I'll just set up a few of the facts here and then bring in Mr. Holmblad, and then after his statement, then I'll make a few other statements to close out. Okay, thank you. Well, thank you. We're here today, obviously, because of a very traumatic incident that took place in February of 2022. We deal with traumatic incidents in this community, as does every community, every day, unfortunately. This is one that's quite unique in nature. And it certainly underlies the entire reason why we're here and what essentially the next appropriate step should be here. The reality is that as we now know, a gentleman named Keyshawn Thomas was died in the custody of the District 5 police just a couple of days before this incident on February 25th. He was a close friend of Mr. Parker Bell, and Mr. Parker Bell was grieving his loss. This is indicated in the criminal complaint, and there's really no dispute about this. And Mr. Parker Bell then dealing with his grief, essentially ultimately entered the police station at District 5, and where he was armed with a pistol and had a conversation with Stephen Holmblad, Holmblad. He's a longtime police officer who ironically was just weeks from retirement as he was working the front desk at the counter at the District 5 police station. It's a public facility. There were other members of the public in the lobby at the time, seeking whatever assistance they needed that day. There were other members of the Milwaukee Police Department staff, civilian staff, actually working in the office area. It is a working office. They were all behind the counter area, behind Mr. Holmblad, Officer Holmblad. And essentially, Mr. Parker Bell came to ask, inquire about the death of his friend. Officer Holmblad had no information to give him about it and said as much. And after just an encounter that literally lasted half a minute, Mr. Parker Bell retreated a few steps, withdrew his pistol and fired one shot into the floor. You can see in video, and this video has been public for now some time, Officer Holmblad ducks literally behind the counter and then looks up to try to figure out what should happen next. And he'll give you his own words here in just a couple of minutes. But the video clearly demonstrates then a shot fired by Mr. Parker Bell pointed directly at Officer Holmblad that literally pierces the glass between the two of them and comes within inches of striking Officer Holmblad. This is clearly a devastating incident in and of itself that could have been deadly, could have resulted in serious injury, and everybody in that police station was endangered by the actions of Mr. Parker Bell. He fired another shot, which of course then really anticipated the response you would expect at that point in a police station with armed police officers, which was that another officer came out from behind and started firing shots back toward Officer Parker Bell while in the lobby of the station. At this point in time, Mr. Parker Bell left the police station and ran through an alleyway or down the street in the nearby neighborhood. He was being pursued now by a number of officers, and while still in possession of the firearm, fired no more shots, pointed the gun toward the officers, which ultimately elicited commands from them to drop the weapon. He did not drop the weapon. Ultimately, officers fired and struck Mr. Parker Bell, fortunately only wounding him, and he was taken into custody. I think it is significant, frankly, that we've known essentially from the beginning what the purpose was from Mr. Parker Bell in going in there. And essentially, he indicated his grief at the loss of his friend. He indicated his desire for his own life to end. And his method by doing that was to essentially go into the police station and fire shots in the police station, which he thought would exact the response that would result in his death. Unfortunately, it's also, of course, resulted in a level of trauma suffered by 8 individuals directly and others who might not have been in the line of fire, but certainly were in the building that day. What I would like to do at this point, I have some other comments I'd like to make related to the length of the the commitment that I think is appropriate. But first, I would like Mr. Holmblad to come into the courtroom, and he's got some comments that he'd like to make to the court.
Okay.
Thank you, Aaron.
Good morning. If you could start off, first of all, thanks for your patience today. If you could start off, I know Mr. Lovern told us your name and spelled it, but if you could spell your first and last name for the record.
My last name is Holmblad, Holmblad. First name is Stephen, Stevn.
Thank you very much for being here today, Officer Holmblad. What would you like to tell me today?
Well, let me just start with, I constantly think about what happened that day. That does not go away. The beginning of that incident, right prior to the incident, I should say, I had a female come in and was making a complaint about a sexual assault that had happened to her. It had happened 6 years prior by a family member, resulting in a child. As I was dealing with that, I had just come back and sat at my desk when Mr. Parker Bell came into our district. He started to speak with me. I couldn't even hear him from my desk. I had to get up to go up and get up closer to the desk so I could hear what he had to say. He asked me what had happened to his brother, and I says, I had no idea what he was talking about. He says, I don't know. He said, my brother died here the other day. I said, okay, I knew that there would have been an incident where an in custody death. I says, first, I don't know anything about it. Second part of that is even if I did, I can't talk to you about it. This is an ongoing investigation. And that was our conversation from beginning to end. That's when he retreated and grabbed his gun and decided he was going to start shooting. Well, luckily the first round went off and hit the floor instead of at me, which caused me to duck. But what doesn't show on a lot of the other videotapes that they show on the TV was he reached his gun over the counter to shoot at me again. Then, when she realized his gun wouldn't fire because it was a class 1 malfunction, it was what we call a stovepipe in the industry, to where a casing gets stuck actually in the gun so that it can't recycle. He actually recycled that. He actually cleared that malfunction by scooting back and moving, actually throwing rounds out on the floor. By the time I popped back up to find out, and I had my gun at that point, I popped back up to look to find out where he went. He was already on the other side of the room. By then he had shot his next round at me. Everybody that was in that room thought at that point I got hit because it was that close to my head when it went off. I scooted across the floor, coming up someplace else. I was going around the corner. Meanwhile, he and another officer were firing rounds back and forth over the top of where I was crawling. When I popped back up, he ran out the door. He was gone. It was not just of the incident that happened that it was at me, but everybody that was in that room at the time. There was the pregnant lady that was there that was making a complaint in the lobby. There was 2 homeless people in the lobby. I had 2 civilians sitting that were office workers in our office that were trapped behind their desk at the time of this incident. All those people were in danger from what he had done. One of my biggest fears, because he will eventually come out, and I know this is nothing new, that he is going to, who is going to monitor him so that he does not go right back to what incident that we just had happen to us. Because next time he comes out, is he going to, instead of coming into a police station, is it going to be a school? Is it going to be a sporting event? Is it going to be what to cause him to go off and do this again? And when he does, who's ultimately responsible for that? I personally, if there's a hearing, I will be there. If I'm still here, I will be there. Because even though that I no longer work for the police department, I still have a responsibility to this city to try to maintain safety for all of us. For the community, for all of us that do our jobs every day. That's much what I personally believe. And if there's anything that I can do to protect that comment, I will do that. And that's about all I have to say. Thank you, sir.
Thank you very much for being here. Thanks for your service to the community and your continued pledge to serve and protect our community. I appreciate it. Thank you.
So as to the ultimate disposition moving forward here, there's obviously no dispute that Mr. Parker Bell has suffered a lifetime of trauma, and I've certainly seen that in the reports done by 3 highly respected doctors in this case, who all agreed that that the NGI status was appropriate here. There's no question, based on the submissions from the defense, that that he's suffered greatly in a relatively short life, but throughout his entire life. He's been victimized personally. He's had unstable family situations. He's had harmful family situations. He's lost many loved ones in his life. One could say that while we see people who suffer trauma every day in this facility, it could be that for his age, he suffered a disproportionate amount of trauma relative to the number of people we see even in this courthouse setting. And that's real. And I've not ever from the beginning disputed any of that. What I think that underscores, though, the fact that that a significant response is required here. I know this court's aware and council is aware. There's a maximum we've said many times in the system that hurt people hurt other people. And there's no question that Mr. Parker Bell's been hurt many, many times over the course of his life on a consistent and deep basis. And we see this every day in our community. The upshot of that in this particular situation, of course, is that also the level of hurt caused by Mr. Parker Bell is significant here. Fortunately, not deadly. Fortunately, no serious injuries, but clearly significant. And as we think now about, and I know this court will carefully evaluate the level of trauma suffered by Mr. Parker Bell. We've also got 8 individuals now who suffered an amount of trauma as a result of his actions here, and I think it's important to take that into account. I think obviously after the 3 doctors evaluated him, and we have the WCS evaluation from Ms. Whitaker, it's clear to the state that Mr. Parker Bell is just really at the very beginning of his treatment journey here. I think that was evidenced and spelled out fairly clearly by Ms. Whitaker in her report, indicating that he's essentially he is a significant risk of bodily harm to himself or others, or of serious property damage. Her report indicates that at this point, he demonstrates minimal insight into his own mental health diagnoses, first essentially learning of his diagnoses through this court process. And even then, I'm not sure there's a consensus yet about what that diagnosis will ultimately prove to be. As many mental health cases go, sometimes a first diagnosis isn't the ultimate diagnosis, or there can be 2 or 3 situations going on at one time that require a response. There's no question here that the volatility of his actions in February of 2022 make him appropriate for confinement in the institution and from a commitment to the institution. And what I would suggest is for a lengthy period at this point in time. I don't think, I think it's important that he recognizes it. Clearly, he said that in his interviews with the doctors, and that's a good first step, of course, and it's only a first step of many to come before he really receives a consistent diagnosis and treatment regimen for him to address the hurt in his life. So the state's position is that the lifetime of trauma suffered by Mr. Parker Bell really requires a significant period of time in a secure treatment setting at this time, and clearly period of time for intensive monitoring of his health down the road. He is a young man still, and the hope would be that even with a lengthy period of commitment within the institution and a significant period of monitoring beyond that time in a secure setting, he could still, the hope would be that he could have many good years of good health after this process of treatment and intervention that he so desperately needs. But it's certainly not something, the level of damage he suffered as identified by all of the medical professionals and by Ms. Whitaker in this case, certainly is not something that can be unwound overnight. It's not something that can be quickly or easily dispelled. And the risks to himself and others require at this time a significant amount of commitment to the Department of Health Services. So under the circumstances, the state is recommending 25 to 30 years of total commitment time to the Department of Health Services. That's for the 4 counts of counts 1, 2, 3, 4 of the amended information, 4 counts, first-degree recklessly endangering safety, use of a dangerous weapon. The court is aware of the 1 prior conviction he had from 2019, a misdemeanor endangering safety offense. And other than that, he has no other prior record of which I'm aware. Under the circumstances, I would ask the court to follow the state's recommendation. Thank you.
Thank you very much. Mr. Appleton-Towns.
Judge, thank you. What we're doing here today is different than a sentencing. Everybody knows that. The court knows that. What we're asking, what's to be determined today is whether or not Mr. Parker Bell needs institutional care initially or released to the community. And it is our stipulation, our agreement that institutional care is appropriate up front. And then Your Honor has to determine the length of his commitment. How long is Mr. Parker Bell going to be under the supervision, under the control of the state to get him to the point where he is no longer dangerous to himself or others? That's what we're trying to do today, not to punish him, but to keep him safe and to keep the community safe. And so we're sitting here today in 2023 trying to make educated guesses, educated speculation about how long that's going to take. To do that, I think, of course, need to look at this particular person, Mr. Parker Bell, need to look at this particular incident and what led up to it and what it was exactly, and this particular mental health issue or mental illness that Mr. Parker Bell presents with. So as to Mr. Parker Bell as a person, you've read reports, numerous psychological reports that talk a lot about his background and his history. Each report that was written referred to Mr. Parker Bell in their interviews as being polite and cooperative. He was always polite and cooperative, and I join in that. He's always been polite and cooperative with me, with the exception of very early on in our relationship when he was actively psychotic and felt that was paranoid about my presence as representing him, but he has overcome that since starting to take medications. Mr. Parker Bell, as the state just pointed out, has 1 misdemeanor conviction, no other juvenile or adult adjudications or convictions. He is a Milwaukeean. He has spent some time in other states for shorter periods of time, but he basically grew up here with his family, most recently living around 30th in Wisconsin. Living there with a girlfriend of his. Her name is Angel. They have a dog together. They've been living together at trying to make a house together for the time period until he was arrested. They don't have any kids. Mr. Parker Bell has no children. Mr. Parker Bell went to high school. He graduated from Bradley Tech, class of 2017. He graduated on time. There's some indication that he had some IEPs in his history, but nonetheless, again, went from grade to grade until he ultimately graduated. He was working after graduation. He was working at the time this happened, he was at Batteries Plus. Before that, he has job experiences at Walmart and at a Cousins and working DoorDash as well. So he's been able to live a socially positive life, trying to get jobs, trying to maintain jobs, trying to build a household. Doesn't really have, well, the court can conclude whether he has a AODA problem. He has openly and honestly expressed to the evaluators that he has some history of using alcohol, some history of using marijuana. to see. Mr. Parker, when this all happened, what happened as described by the state. That was an accurate description of what it is that happened inside that police station. Leading up to that, though, to flesh that out a little. He went into that police station with an irrational, unreasonable goal. His unreasonable and irrational goal, driven by his mental health, was to be killed, to commit suicide by police officer, by going into the police station, brandishing a gun, firing that gun, forcing the police officers to shoot at him with the hopes that they would kill him, that he would die at the hands of the police, like he believed Keyshawn, his friend Keyshawn, had passed away. Mr. Parker Bell, since the beginning of when we've talked about this case, has disclaimed any intent to actually shoot any people. He was in this lobby. I don't think that lobby is even as big as this room, and in that small room, there's about 7 or 8 people, and Mr. Parker Bell is firing that, and if he intended to fire and hit other people, it seems that he could have easily done that. His drive, his intention was not to shoot any people, but to fire off weapons and have him be shot, to have them return fire and shoot at him. He was shot at in the police station and ran outside, which I'm thankful for, because didn't put the people in the lobby in danger any longer. He was chased by police about a block away. His gun was jammed. He could not fire his gun, but Mr. Parker Bell made it clear to the police that he was still brandishing that gun and threatening to use it with them. He was showing it to him. He was saying things like, "I'll shoot," because he was still trying to be shot by the police. He wouldn't drop that gun, even though he could have. He was shot by the police and arrested. He had a bullet wound in his arm, his leg, and his back. He was taken to the hospital where he had to be treated for that, of course. At the hospital, he begged all the hospital staff to let him die there. The hospital staff was noticeably concerned about the things he was saying, his suicidal thoughts, and how consistent they were. And the medical records from his treatment at Freighted indicate that they were advocating hard for a Chapter 51 type commitment rather than police prosecution, but that decision had already been made, and their hopes for a 51 was overruled. He was taken into custody. These voices, as been made clear in all the records, all the reports about this, these voices were compelling him. They were urging him to go in, to ask about his friend Keyshawn, and to die by police shooting, because he was worthless and because there was no reason for him to be living. The voices that Mr. Parker Bell has described, he said he first noticed them and asked his grandmother about them when he was very young, about 8 years old. And he said that she told him it's a gift from God, and that he was lucky for that. But those voices persisted for years. Mr. Parker Bell has not acted violently against other people previous to this incident where he put all these people's lives in danger, but he has not had a history of acting violently against other people because of what the voices are telling him. The voices are consistently pointing towards self-hate, towards telling him how worthless he is and that he should die. He has had a history of suicide attempts since about 14 years old. He has, I gave the court, I filed with the court some paperwork about people that were very close to Mr. Parker Bell who had died rather violent deaths in the months leading up to this February incident. Family, friends, cousins, his stepfather, the person who was the boyfriend of his mother for many years, died violent deaths. Milwaukee can be a very traumatic place to live if you are poor and you are exposed to the types of violence that happens in our city in some neighborhoods. Again, Mr. Parker Bell lost a number of people leading up to him losing his best friend, Keyshawn. And all of that added to Mr. Parker Bell's feelings of worthlessness and feelings of helplessness. Nothing else that he could do about it. I want to talk about the specific mental health issues. The doctors at this point, and Mr. Laverne is correct, sometimes diagnoses evolve and change. Certainly medication regimens will evolve and change, but they seem to settle on a major depressive disorder with psychotic features, and that seems to recognize what it is that Mr. Parker Bell is going through. Slightly different than PTSD, or what our understanding of PTSD is, but it is also informed by those prior traumatic experiences that he had. Mr. Parker Bell, despite these voices and his concerns about them, was basically unaware that he was so mentally ill at the time. He was unaware of what his diagnosis was or his need for medication at that point. He had not had any formal psychological, psychiatric therapy or treatment to that point. Like Mr. Laverne said, this process kind of showed Mr. Parker Bell that he has this mental health problems. And since then, we've been able to watch him as he's lived in the jail, lived with this diagnosis, and begun to be presented with medications. Mr. Parker Bell has consistently been medication compliant in this matter since they were assigned to him. He has consistently expressed a remorse for what it is that brought him to be doing what he did on February 25th. The doctors variously credit him with, I have a quote here, has great self-awareness. He has an insight that is short in length. Granted, he has not been dealing with this mental health for very long, but is a significant level of self-awareness. To wrap up, excuse me, what we're asking for is for an institutional care initially, and for a total length of commitment for Mr. Parker Bell to be 10 years long. Of course, Mr. Parker Bell during that period will be able to apply for and hope to get released to the community, so his transition to the community continue to be supervised, such that he's safe and everybody's safe. And that's what we're looking to try and do. What's needed for Mr. Parker Bell to show that he's safe to go into the community, I think, is at this point a track record. He needs to display a track record that he is a person who is safe. We need a track record of medication compliance. We've been very good about that at this point. He's taken the medications they've given him. Mr. Parker Bell still hears voices. They're a lot quieter than they used to be. They're a lot less violent than they used to be, but he still hears voices. He still has concerns about self-harm. And that will improve with the different medications that will be closely monitored by him when he is in custody. So the right meds, we need med compliance. We need his compliance with therapy and psychological treatment to make sure that his awareness is sustained and increased, his understanding of what he needs to do in order to keep the community safe. He has a history, Mr. Parker Bell has a history of non-criminality. He has a history of non-violence. This excluded, this is a very violent situation, and I'm not trying to dismiss that as nothing. It's a very serious situation. But before that, again, his history has been one of self-harm and that feeling of worthlessness. He's got a history of supervision success in that one period of probation that was offered to him when he was convicted of his misdemeanor. That was completed successfully, and he even attained expunction of that conviction. So when he has a goal, he can successfully get to that goal. He has a history of doing that. And he needs a history, a track record of family support. He does have a history of that, and that does exist. People are here today in support of Mr. Parker Bell. People have been helping me to get to where we are right now, to be able to fill in the context of who Darian Parker Bell is and what he needs. Judge, in 10 years, he'll be about 34 years old. He'll be a much more mature person than the, frankly, late adolescent that he is right now, and he is at the time when this happened. I think that there is every reason to believe that he will be in the period of these 10 years, We'll continue to establish a track record such that he will be, when it's safe, released to the community. And eventually that this condition of that this commitment will terminate and he'll be able to go on with his life in a way that's safe for him and safe for the community.
Christina, can you let Hampton know that Shelton's looking for him? I'm sorry, go ahead.
No, Judge, thank you. That concludes my comments on the reason why we think that's an appropriate length of a commitment.
Mr. Parker Bell, do you wish to say anything today?
I apologize for my actions.
Thank you, sir. So today, as we have outlined, the court needs to make a finding as to whether or not Mr. Parker Bell would pose a significant risk of bodily harm to himself or others, or present a risk of significant property damage. The parties have stipulated to that, and there is overwhelming evidence in this record of that, given the violent nature here. So the question is, how long does Mr. Parker Bell need to be committed under as a result of these acts? Mr. Parker Bell has pled guilty, has entered these pleas, and we're here on 4 counts of first-degree recklessly endangering safety with the use of a dangerous weapon. The maximum period of confinement is 50 years combined. The state has recommended 25 to 30 years. Mr. Parker Bell and his counsel have recommended 10 years. As I look at this, the horror that's represented by what happened here can't be overstated. And the difficult thing for Officer Holmblad and the other people who were in that lobby that morning is that bullets do no less damage because they're fired by someone who, like Mr. Parker Bell, has these significant mental health issues. As is so often the case in this courtroom, there's just so much trauma at both tables, because there's no question that Officer Holmblad and the other individuals who were in the lobby that day have suffered significant trauma. And among the downsides of our system is we're not offering them any treatment, any help. They have to get that on their own. And I hope that they are getting it, because if I believe anything as a result of being here for the length of time that I've been here, it's in the incredible impacts of trauma and secondary trauma and our need to address those things. So there's this significant trauma there. And then I look at Mr. Parker Bell, who has no real significant prior criminal contacts, is clearly suffering from a mental health crisis. And what I'm being told is that this is a mental health crisis that was close to 10 years in the making. If he started hearing these voices and attempted suicide since 2014, it's troubling. I mean, clearly, I'll make a note. I didn't count it, but there's probably 10 or so people here on behalf of Mr. Parker Bell. Those folks are not just here today. They've been here pretty much every hearing. So it's clear to me that Mr. Parker Bell has love and support in the community. One of the things that's troubling about that is that love and support didn't make mental health services available to him. And I understand that it's not uncommon, because for some reason it's seen as a sign of weakness. And so it's just unfortunate then when he started hearing voices at 8, family members who loved him and supported him told him that it was a gift from God and not something that required treatment, because I have no doubt that had Mr. Parker Bell been connected with appropriate resources at that age, that he wouldn't be sitting here today. I also do have to note that it's hard for Mr. Parker Bell to view himself as fortunate, but he is incredibly fortunate that he wasn't killed by the police on that date, even though on that date that may have been what he wanted. It's somewhat perverse to say this, but this may be the event that turns Mr. Parker Bell's life around, gets him the treatment, and puts him in a position to be a more healthy member of the community. I think that's going to take a long time. And the level of threat that he represented to the community on February 25th of 2022, incredibly high. As Mr. Applin Dobbs said, we are trying to predict the future here today, which is very, very difficult. However, there are two elements to this. Obviously, Mr. Parker Bell is going to need institutional care, but under the NGI laws in the state of Wisconsin, he will eventually be able to transition into the community. Officer Holmblad talked about who's going to be supervising him and who's going to be responsible. And, Officer Holmblad graciously and generously has said he's going to continue to be involved in this. And I understand that, but there will be supervision in the community. And so at some point in time, presumably, I should say, because I presume that Mr. Parker Bell, having been given a diagnosis, being receptive to treatment, being receptive to medication, will at some point in time likely, certainly he can petition for, and it's likely at some point in the future that a court will find him appropriate for conditional release. And from this court's perspective, giving a significant amount of time for that to happen, and to make sure that Mr. Parker Bell not only gets the treatment in an institution, but also has the ability to get treatment and help and supervision outside of an institution is appropriate, and the court does take that into consideration. Balancing each of those things, the court does believe that a term of commitment consistent with that recommended by the deputy district attorney is appropriate here. On count one, the court is going to order a commitment of 7 years and 6 months. On count two, the court is going to order a commitment in the length of 7 years and 6 months consecutive to the time in count one. On count three, the court is going to order a commitment in the term of 7 years and 6 months consecutive to the time in count one and two. And on count four, the court is going to order a commitment of 7 years and 6 months consecutive to the time in counts 1, 2, and 3 for a total of 30 years. Now, that does not mean that Mr. Parker Bell will be institutionalized for 30 years. What it means is that Mr. Parker Bell will get the help that he needs for the next 30 years. And I think that is appropriate. That's appropriate to give him the time that he needs, the treatment that he needs. And it's also appropriate for the community because the impact of what Mr. Parker Bell did, obviously it impacts Officer Holmblad. It impacts the people who were present in that police station that day, but it also impacts tremendously our entire community. I mean, think about the young lady who came in to speak to Officer Holmblad to report that sexual assault. She went to the police because the police station should be a place of safety and a safe harbor for people in our community. It's a people that we can turn to when we are in trouble and when we feel threatened, when we feel in danger. And on that date for that time period, Mr. Parker Bell shattered that sense of safety that we should feel. And I'm not naive enough to not understand that not every member of our community feels that way when they go into a police station, but that's the goal, that's the purpose, that's what every officer is there for. And like any human endeavor, it's not perfect. That's what we're striving for. But what Mr. Parker Bell really did that day takes greatly from the community. So that's another reason why I think that length of commitment is appropriate. So that is a total of 30 years. That he doesn't have any other sentence. So that commitment is effective today. You'll calculate his pretrial credit, Mr. Opland Dobbs,
464
to today or to yesterday?
to yesterday, to the.
So 464 days credit against that. Because these were felony offenses, Mr. Parker Bell, you can never possess a firearm. They were violent offenses. You can never possess body armor. And those restrictions remain throughout. Good luck to you and your family. You've undergone incredible amount of trauma. I know that no one would ever want to be sitting in your chair facing what you're facing, but you have an opportunity to use this as the moment that turns your life around in a positive fashion. Because I know the deputies don't like it, but you'll see them when you walk out. You'll see the number of people who are here to love you and support you because they know worth, and you'll continue to have worth, and they're going to be there for you. And I hope someday you recognize your own self-worth, so that you're not driven by these voices, driven to self-harm and the harm of other people. Good luck to you and everyone. Thank you very much, Mr. Parker Bell.
Okay, he should
Thank
be
you.
coming up now, you guys. That was the long one.
So let me know if that makes sense. Okay.
Hey, Sadie Saddle. Yeah, they had to push him back. Oh, there he is. Ugh. He got his Jeffrey Dahmer glasses on.
Okay. Yes. All right. So he obviously is committed to a state facility for that length of time. All right. All right. Good morning again, Mr. Brooks, Mr. Rakestraw.
Here.
I think we may have sent Mr. Hampton to another court.
Okay.
But my understanding is that the parties have reached a resolution on Mr. Brooks's case.
That is not the case, Your Honor. It appears that we are, as of right now, are still on for trial.
Okay.
I would ask that the state, if they're willing, to leave that offer on the table until the day of trial, Your Honor.
All right. Well, this matter. This is State of Wisconsin versus Daryl Brooks. Can we look these folks up? Case 20 CF 2550. Appearances?
It appears by Jacob Court. Good morning, Your Honor.
Daryl Brooks appears by Attorney William Rakestraw, Your Honor. Good morning.
Good morning. We're on the calendar today for final pretrial. The records reflect that Mr. Brooks was produced from Dodge Correctional. However, there was a staffing issue in the jail. And all right, I'm sorry, Mr. Hampton, are you going to appear?
Oh, yes, Attorney Hampton also appearing with Mr. Brooks. Good morning, Your Honor.
Good morning. I apologize. I thought I'd lost you to another court. We're on the calendar for final pretrial. Mr. Brooks is appearing via Zoom. Mr. Hampton's in the courtroom. Mr. Rakestraw is appearing via Zoom. I had put Mr. Brooks and his lawyers into a breakout room And then this was delayed because there was another hearing that I needed to call. Mr. Brooks's case is set for trial on July 10th. Mr. Rakestraw has informed the court that Mr. Brooks is still in trial posture. Mr. Cord, does the state anticipate being able to go forward on July 10th?
Yes.
All right. I know there had been discussions and there was a request from Mr. Rakestraw that the state leave an offer open. Can we make a record as to what that offer was?
Judge, I was, count 1 and count 2 were going to be dismissed. Count 3 would be pled to. I believe the recommendation would be a prison sentence determined by the court.
With defense free to argue.
Correct.
All right. And just for the record, Mr. Brooks, are you aware that that's the state's plea offer on this case?
I am, Your Honor.
All right. Okay. So at this point, we're set for trial on July 10th. Is there anything else we need to address on today's date?
Judge, only that if this case were to resolve, I would ask if I could get notice maybe the week before, just so I don't have to bring in my witnesses. We don't have to have another court date scheduled, but if I could get notice from Mr. Brooks and defense counsel that that's where we're going, I would appreciate that.
I would appreciate it as well. This court will be down the week before, but if you can communicate with the court via email, because I anticipate that if we go to trial, I'm going to have to make some arrangements because I don't, there's a limit to the number of people we can bring over to this courtroom for voir dire. I think that we may need to conduct voir dire with a larger pool than I would ordinarily do. And so I'm going to have to make arrangements on that. So the more advanced notice we have, the better. Anything else we need to address today, Mr. Core?
No, Judge, thank you.
Mr. Rakestraw, Mr. Hampton?
No, Your Honor.
All right. Thank you very much. We'll see everybody July 10th. Thank you.
All of that waiting for that. That's what we got. Well, we're still on for the 10th. Yeah, but I agree. Somebody, who was it that said that? He was giving his attorneys a hard time. I forgot who said that. I apologize.
Good morning, Judge Sanders. Good morning.
Let's
Ms.
take this
O'Byrne.
off the screen.
How are you?
So yeah, I think you're right. I think he was giving his attorney a hard time. Does he behave better for a male judge? I don't know. I think it's just different circumstances, guys. I mean, Toby thinks he's going to fire his lawyer on July 10th. Could be. Could possibly. I mean, the one guy that spoke first, the one attorney that spoke first that was on the Zoom, he does seem agitated, does he not? So that's probably, they're probably like, look, you're not going to get any better than this. And can you imagine they're having to deal with him on both these trials too? They got to deal with him on Erica's trial. All right, so the trial for this particular charge, and I'll remind you guys again, I've got it scrolling at the bottom. It's the 2 charges for the second degree recklessly endangering safety. Basically, he pulled a weapon, a firearm on his mom and nephew, and there's 2 separate charges, one for his mom, one for his nephew. I don't know if mom would have been able to dismiss her charge. Could she have pulled back and dismissed that? Possibly. I don't know. But he's also got a count for, there's a charge in here for him having a firearm and being a felon. So there's that. And then this trial is going to go to court on July 10th at 9 a.m. That is 9 a.m. Central Time, and we will be here for it. We will be here as long as it takes. Sarah Boone's pretrial starts on the 11th of, which is a Tuesday, the following Tuesday. And probably what we'll do is if we're streaming Brooks's trial, we'll probably play her pretrial hearing during one of the breaks or during the lunch hour or something. So that'll be good to kind of go back and watch that. Also on the 13th of July, we have the sentencing for the Wests, who unalived Orrin and Orson West. If you guys remember those cute babies. I did a lot of stuff on their trial. So we're wrapping that one up. So again, we'll probably play whatever they show on a break if we're watching the Brooks trial live. If not, I'll go live specifically for those other 2 items. And then Sarah Brooks' trial is set at this point, as we still believe, is set to begin on July 24th. And maybe by that time, her case will, the Brooks trial will be over and we can just start live streaming Sarah. Now, Brooks does have that pretrial hearing for Erica's case on the 21st of July at 10 a.m. Central Time. So we'll be on there for that as well. Here's what I'm thinking. If he's still in court and that trial's not over, they'll probably push that back. So we won't have to worry about any kind of conflict there because obviously they can't be in two places at one time. And then if that case continues with Erica, oh, and the case was when he tried to run over Erica with his vehicle in the gas station parking lot. That trial will begin on Monday the 14th at 8:30 a.m. Central Time. And again, we will be on live streaming for that trial as well. So I'm kind of thinking that if Sarah's trial ends up where it's going to be on the 24th, that might be perfect. We're going to have like back to back to back 3 trials going if they don't all take more than 2 weeks at a time. And yes, I'm looking at a paper calendar that I have written in these things because I just work that way. I'm old and I'm decrepit. That's right. I'm sorry. I thank you for correcting me on that, Mel. He didn't try to run over her. He did run over her. She had injuries. So, what do you guys think? You want to finish watching this other thing and I'll let you guys let's finish watching what we were watching earlier and then I will let you guys kind of we'll do a little sign off after that, but we're kind of enjoying.
The first thing you're going to need before anything else is that Sovereign Citizens Handbook. I don't know where you're going to get it, but you need to get one. Now, they might have them online. They might, if you're already in prison, you might can find one from somebody there that's already next to, maybe a cellmate or somebody that's not giving you a hard time there in prison. If you have friends in prison, they might have one. Okay. So, yeah. So let's start with our checklist. Now, Mr. Brooks does say that we should utilize all the items that the court provides for us. And you know what, people? These items are free. They're free of charge. So let's go through a couple of them. Now, Mr. Brooks, his court trial was in 2022. And as you guys know, COVID-19 was effective in 2020 when they shut down most of the United States. Oh, shoot, most of the nation for COVID. So, what Mr. Brooks recommends that y'all do is go ahead and utilize that mask. I mean, go ahead and wear that mask. I mean, here's the thing. If you have shame because you're in the situation that you're in, that's just fine. But people are going to be taking all kinds of pictures of you. You might even be on video. So what we say y'all need to do is go ahead and put that mask on. It's going to help you. It's going to help you in the long run. And two, there might be some witnesses that come up that can't even recognize you because you got that mask on. Now they might tell you take it off from time to time, but we're going to show you how to take it off, put it right back on. So y'all can watch this video right here and see that.
When he came out from the garage, he was asking if I could call him an Uber.
Okay. The person that you're describing for us, sir, do you see him present in the courtroom here?
He's sitting over there with the mask on and in the suit.
Okay, I'm going to ask the defendant be instructed to remove the mask. Mr. Brooks, please remove your mask. And if he would look at the witness, please, Your Honor, with his head down, it's not to assist.
Right, Mr. Brooks, please look up and look at the witness. Look at the witness, please. Thank you.
Now, the other thing is the prison Bible. You want to make sure that you take a prison Bible with you to court at all times. It can just be sitting there on the desk. It needs to be visible. You want to make sure you turn the book sideways so that the side of it that says that it's a Bible is facing towards the jury. And you just want everybody to know that you're a Christian person, or think that you're a Christian, because it might help it just might help you. So just if something comes up and like what you're waiting for a real long time, what you can do is you can just pretend you're reading it. Heck, you could read it if you want to. It don't matter. But you know, if you want to read it, you can. But Mr. Brooks really thinks that it's essential. It's essential in your case. All right. The other thing we want to talk about is when we're utilizing all of the items that are in the courtroom and around us, one of the things that we want to talk about is how the guards handle you, how they utilize different types of mechanical items or restraints against you. Now, Mr. Brooks had, in his case, he had a shock device on his ankles. He tells me this all the time. So, I think where he thinks where he messed up was that by not telling the court that those anklets were going off on shock devices all the time throughout the court. He was just taking that pain. He was taking that pain in and he wasn't telling nobody it was there. He waited till the end, towards the end of his trial. So what he thinks that y'all should do is just go ahead and every time they set that shock device off, you need to just jump at it and tell them my ankle, my shocklet's going off. Now, if you don't have chocolates or that's what we call them, chocolates. If you don't have a ankle device that's got electrical waves going through it to shock your body, then what you could do is you could just pretend that you do. And at the end, like say towards the end of the case, when things aren't going great, because it could be, because you know, we don't make no guarantees here at the Darrell Brooks School of Law. But if your case is not going well and it doesn't look like um, you're going to be able to get off the charges, what we recommend that you do is state that those anklets, whether or not they are, state that they are shock devices. And you could throw a big fat tantrum in the courtroom and just go off. And we're going to show you right here how to do that. Okay. One moment.
Important to have a thorough record of the restraints that were utilized. The photographs that have been provided are on a compact disc. They will be filed as Court Exhibit 3, but they will remain under seal. And that is because of the security concerns related to how the Sheriff's Department secures inmates during a trial. That certainly is an overriding interest, overriding any public interest to see what those restraints are. And I would just further note that during the trial, when Mr. Brooks would be brought from the holding area into the courtroom, this courtroom was closed to the public. And that was really to maintain that privacy, if you will, or secrecy, if you will, regarding the restraint system. And so I believe it's important that that information not be released to the public. It will be available, of course, to the court and the parties. And if there is an appeal, any attorney that may represent you can certainly look at that, but it'll otherwise be under seal. So
Why would
the
that?
record is very clear on the restraint system that was utilized during this trial.
I have a question to that.
Okay.
Why is that remaining sealed, but everything else being open to the public?
I've indicated my reasons are on the record. I'm not going to restate them. So
well, I think that the public, if they're allowed to see search warrant information and things like that, then I think that they should know that it was a shock device on my ankles. That
there was no shock device.
It was a shock device. I was told it was a shock device.
Mr. Brooks.
And
that's
it was
why
covered
I'm
up.
the record.
It was covered up by a black cloth, so the jury purposely could not see it, and so that the public cannot see it. I was told that a chair had to be placed on my side so that no one can see that I was shackled with ankle shocks. I think the public should know that. The jury should have known that. That's what they were.
Mr. Brooks, I've made my ruling. Your
I
characterization
respect your
of
ruling,
those
but it
as
should be noted.
Your
it should be
objection is
noted.
noted for the record.
It should be noted that I had a shock device on my ankles. That's fact.
It
It's
is
a
not
fact.
sir.
It is a fact. I'm the one that had them on my ankles. I inquired about what they were. Obviously, I'm going to require about what's being put on my body. I was told that they were a shock device, which I know how a shock device looks because I've been through this before in Milwaukee. So I know what a shock device is. It was clearly a shock device that was purposely not shown to the jury or to the public. Purposely not. And then now you're saying that it's going to be sealed. Well, why should it be sealed? The
All right,
public
Mr.
doesn't
Brooks,
deserve.
you're,
The public deserves
you've
to
made
know.
a record
The
and
public
it's
deserves
noted.
to know about
And
things pertaining to a search warrant, but not the fact that I was limited by a shock device. That if I moved the wrong way, I could have got shocked with all this voltage.
it's absolutely false that you
That
have a
is
shock
not
device
false,
on,
and
sir.
you know that it's not false.
Well, I have the photograph.
Well, show
that
the
will be
where's
part
the
of the record,
photographs? Where's the photographs?
and they
You
will
just
be
said they would be
sealed
sealed. Why do they need to
from
be
public
sealed?
view
Why
for
do
the
they need to
reasons
be
that I've
sealed from
already
the public?
indicated.
Why do they need to be sealed
Mr.
from
Brooks,
the
I
public?
need to move on to scheduling.
Can we move on to subject matter jurisdiction that hasn't been proved for the record?
All right, so
Can we move on to that?
Mr. Brooks, I really don't want to remove you from the courtroom today.
It-
But I need to
don't,
move
I don't
on
want to
to-
be removed, but you're not going to sit here and tell me on the record what was on my body when I was told what it was. That's inaccurate, and I refuse.
At a
Your
later
Honor,
point in time, I
Your
will
Honor,
put.
I refuse to sit here and let you make an inaccurate record when you know that it was in fact a shock device. That's why I had the black cloth in front of the table so it couldn't be shown.
That's
That's
not
why I
right
had
at
a
all.
chair sitting on the side of me that was told needs to cover up the fact that I had a shock device on my ankles. And I think it's very, very, very unfair, and it's dishonorable to get on a record and not tell the truth. I'm not trying to dishonor you, Your Honor. I'm not trying to disrespect you. I'm not trying to disrespect your court. I just want the truth to be told. That should not be sealed. If everything else could be open to the public, then the public should know that I had a shock device on my ankles. That was purposely not shown to the jury or to the public. They should know that.
All right, thank you, Mr. Brooks. I disagree wholeheartedly with your
Well,
characterization.
it's not true.
Mr. Brooks, I didn't interrupt you.
It's
Please
not
don't
true.
interrupt me.
It's not true.
Mr. Brooks,
I'm quite sure it's cameras rolling right now because there are always cameras rolling. There's always audio on.
Mr. Brooks, I need
There's
to move
public,
on to
there's public in the
scheduling.
courtroom. I had a shock device on my ankles, and they purposely did not want to show that to you guys or to the jury. That's
Mr.
why I
Brooks,
can only move
I'm advising you.
here or here.
Mr.
That's
Brooks,
the
I'm
reason
advising
why.
you.
And I always had the chair right here. Everybody that came in this courtroom seen that I had a chair right here, even though I had no counsel. What is the reason for me to have a chair right here?
All right, Mr. Brooks,
Why
any
did I have a
further,
black cloth
any
in front of
further
the table?
interruptions will result in you being removed to the other courtroom
Okay,
because
and
you're
you
not
hold
letting
me in
move
contempt,
on
that's
to
okay.
scheduling.
Is it civil contempt or criminal contempt?
All right, one more interruption and you will go to the other courtroom.
Well, they need to know that.
Stop.
They need to know that. They need to know the truth.
I'm gonna ask the state some questions. If you interrupt when I do that, you will be removed to the other
Okay,
courtroom.
remove me in.
All right,
Remove me
Attorney
in. It's
Basie.
not gonna stop the fact that they need
All
to
right,
know that a shock device
he's
was on my
interrupted.
ankles.
I'm sorry, everyone. We'll have to clear the courtroom. He will be removed to the other courtroom. I'll
That's
make the
fine.
appropriate
Tell the
findings.
truth, though, Your Honor. Tell the truth. I had a shock device on my ankles.
So these are the quick tactics that we like to go through in part one here of the training manual. This is a really short class. We want to let y'all know that you're not alone. That there are many people out there that are in your situation, and they need Mr. Brooks to help them. At the end of the day, when you get to the point to where you feel like, again, you are losing, you're gonna go to jail, and there ain't no way around it because you've tried everything in the book. What you do then is you continue to make excuses. Tell them you don't understand what's going on. The other thing, too, is to be combative. And we're going to talk about those two items in the next chapter of the manual. Just make sure that you watch the next video when it comes up so you'll know how to defend yourself as a sovereign citizen. You, too, can get off your charges.
The record and State versus Brooks appearances are as they were before. Mr. Brooks, if you interrupt me, I will mute you so that I can make an adequate record regarding.
Anyway, Your Honor.
All right, he interrupted. I will mute him. I need to make a record of his removal.
Okay, that is it. So I want to thank everybody for being here with us today. You guys hung in there. Only took us 2 hours to listen to 5 minutes worth of information. So go figure. I guess we're getting used to it by now, though, with him. Dude, find a nail clipper. Kim, I'm with you. I know. The man needs a manicure. I don't know if he can recall what other things he can't remember at this time. United we stand. But welcome in with us, United we stand. Good to see everybody. You guys be safe, be good, have a great week, and be on the lookout for some other stuff I got dropping this week. So blessed to have you guys here in my community. Thank you so much for your support. And don't forget to hit that like button and subscribe button on your way out. Be good, y'all.